Hi there. Today I'm chatting with Greg Woollaston. Greg's a partner at Dewhurst Law and also a College of Law lecturer on our master's program. So great to have you here, Greg.
Good to be here.
Hey, look, really appreciate it. I know you have always been a big supporter of our students and also the profession, and you and I have just had a little chat just around the concept of resilience and well-being and change. So really appropriate and appreciate your time. So given what we've been through and what you've observed over the last sort of 5-6 months on where New Zealand is at and perhaps where law is at, what's your thoughts on what you're seeing?
Well, New Zealand, I think, is in a relatively unique position in that the remoteness has often been seen as a disadvantage in terms of structural access to marketplaces and economic opportunities. And it may be that as the pandemic continues and tragically worsens in large swathes of the world, and in particular in the developing countries, that the degree of geographic remove that we've previously bemoaned in terms of economic access might afford us a greater protection, or at least a better opportunity for managing and mitigating the risks from the viral exposure. But that also has to be seen as the psyche of the country, that has to be seen as a double-edged sword, because that leads to the potential for isolationism and regression from the community of nations, if I can use the political speak. And I think that that would be potentially problematic for the economic development in the more interpersonal spheres, the educational sector, those sorts of environments. So it might be a boon for the agricultural sector, but the integrated interpersonal, by which I mean your software systems, your academic deployment, all of those sort of person-to-person and distributed person-to-person networks, if we become insular in our thinking, there's some risk engendered in respect of that.
Absolutely. So with that, as we've spoken, the legal landscape has been changing and evolving over the last several years. What are your thoughts about how that might accelerate or shift over the next 3 to 5 years?
Well, COVID, I think, demonstrated the archaic nature of some of our thinkings in terms of the practice of law. I have a relatively broad litigation practice profile, so I practice in the High Court and substantively in the Family Court, and I do some resource management law. And family law accelerated because of the sort of dissociative and dysfunction introduced, the dissociative effect and the dysfunction introduced from COVID. So we had a lot of, unfortunately, family violence. We had a lot of refusal to return or engage in respective parenting matters. And for the first couple of weeks of the lockdown, we had solicitors sitting saying, I need to file a without notice protection order. I have a client who is genuinely at risk and needs to be afforded the protections that the family violence legislation, and we have world-class family violence legislation, affords to them, but I'm not allowed to do that unless the documentation has been physically attested by an independent solicitor or a registrar of the court or a notary public or those other approved signatories. So it took 2 or 3 weeks of the lockdown for the machinery to actually recognize that these old forms of execution and practice weren't compatible with a fully digitized court profile. Just in the sheer mechanics of getting something put before and accepted by a judge. I have to say that Parliament was really good in terms of passing riders to the legislation and saying that the administration in respect of the more formal classes of documents can be done remotely. So we could have Zoom attestations, and that cleared the backlog in respect of the High Court. And the Family Court adopted a very sensible protocol of simply saying, you can provide a certificate from your solicitor to say that this is accurate and we will be expecting it to be signed in the conventional format when the lockdown lifts. But what that said to us as a practice is that we haven't moved far past parchment and quill in terms of our actual physical construction of documentation, despite the fact that we have this wonderful technology in front of us. And we have some real challenges in a legal framework because we don't have a sequestered or safe digital profile in terms of how we go about conducting hearings. We have a lot of documents in the family court that are certainly not, they're just not appropriate in any sense to be broadly disseminated. We might have specialists in a Oranga Tamariki matter, we might have a 178 psychiatric report or clinical psych report on either the parents or the children. The disclosures and the matters canvassed in those can be both highly sensitive, highly volatile, and quite traumatic. Now, if we are trying to have a hearing in determination of what's appropriate for disposition of care in an Oranga Tamariki matter remotely, then we run into these really simple but to date slightly insoluble questions or issues of how do we send the trial bundle, which is the collated set of documents, to the respondent father, if he's sitting at home alone and he's therefore going to have a PDF copy of documents which ordinarily wouldn't be released from the solicitor's offices or the court building. So a lot of really simple issues on their face threw up some really complex considerations. And the system ground, I mean, it did an admirable job of addressing urgency in just circumstances which had never been contemplated. But we ground to a halt in terms of substantive trials because we still don't know how you can release a traumatically sensitive report to a father, for example, who may have been characterized as a principal abuser in that report and who has a disposition to harm the applicant. And technology, I think, is going to have to rise, and I have no doubt that the innovation of the IT community will meet the task. We might wind up with dissemination which is locked to a specific computer, or files where you need co-approval for upload or something like that. But at the moment, we've got a system whereby if we went back into lockdown, our big trials involving our most traumatic matters would be very difficult to progress in a manner which was safe for all of the participants. And now that we know we have that problem, I think we're going to need to be looking to that in a fairly rapid instance, because whether COVID abates and we have the good fortune for there to be a vaccine, we now know that this is a reality. And we need a profile for the administration of justice which is sound across all of those eventualities. And what we've found is ours is really good, but it has these deficits.
Great. So real challenges, some opportunities. So Greg, as you're aware, the College of Law has been passionate, and we've had some initiatives over the last several years around the concept of health and well-being in the profession. It is a profession that is incredibly demanding and, at times can be a bit tough on itself, but also, from a delivery perspective, high expectations. So health and well-being now, we believe, is a vital part of organisational performance. What are your thoughts on how the profession, the industry, the firms can do to enhance it?
Well, I think that without sounding the anarchist note in the practice of law, we need to look to a recognition of the individuality of our employees, their strengths and their weaknesses, the reality of their ability to participate in certain functions. I have staff across, we have a distributed office space, and we're just in the process of opening in Wellington. So we've now got 3 or 4 offices running. I have staff who I wouldn't think, because of their past personal exposure to certain instances that ought to be expected to work in relation to family law of a certain type. I have staff that have a particular aptitude for fiscal and computational matters, and I have staff before whom, and this would be my mea culpa, if you put a spreadsheet, our eyes glaze over and we just sort of wander vaguely from the room asking for the pain to stop. But what we've had is an expectation that lawyers, because they have a law degree or they have a law and a commerce degree or whatever it is they come equipped with, are capable of handling all things that are thrown at them, particularly within a general practice environment. And as the law becomes more sophisticated and more nuanced in its application, and as the breadth of data which is bedded into even a relatively simple proceeding expands, because we have litigants now who are trawling around on Google and they're coming up with case law and they're filing quite complicated treaties, even on a self-represented basis, to say to our staff, look, you've got a law degree, now you have to be able to canvass A to Z, as is the old conventional general practice format. That's fairly unrealistic. And to say to everyone that, look, because you've signed up to practice in a law firm, you need to be here at 8 o'clock, by which we mean 7:30, and you need to be able to finish at 5, by which we mean routinely 9,
Yes.
Is just not appropriate, nor is it commensurate with their welfare. Recently, there's an interesting pilot study that was done in Japan, and they introduced a 4-day week as a test over one of the large companies over there, and productivity went up by 14%.
Yes.
Because the macho work culture of, if you're not doing 80 hours a week, you're just not trying, often results in, frankly, fairly exhausted and second-class ratiocination. He says, trying to pluck the word ratiocination from an exhausted mind. And what we need to do to make sure that our people are well is to structure roles which are commensurate with what our people need to be doing. If we employ mum who's a single mum and she's got a couple of 7-year-olds at home, we need to be realistic that she's going to want to make the school run. There are going to be sick days. There are going to be times where if she's doing straight research work, or dad's doing straight research work, they should be given the opportunity to do that from home. Yeah. And I think we should become an output and a quality-based model of practice. Because if we ask our people, and I've always said to all of my employees, I don't care, unless you are due in court, or I need to be meeting with you, or the client is sitting there waiting, wondering why it is Greg doesn't care and he's given you such liberty to not be here. I actually don't care if you come into the office or not. What I am going to want to see at the end of the week is productivity which is commensurate with you having given us a reasonable shot as your employer and a good quality of work. So if my guys are walking around looking like sleepwalkers, I'll say go home, take a couple of days off. We need to look to their welfare. We need to look to their opportunity for refined thought, because that's what law's about. We're not in an industry where near enough should be close enough. We're in an industry where quite nuanced considerations can be very costly, and often, particularly if we're participating in the sharp end of family court litigation, the difference between adequate and good representation can be the difference between retaining the care or positive engagement in your child's life and losing that principal caregiver role. And sometimes the detriment which flows from an adverse outcome is very significant for the children. So applying a model which is consistently, we need you to be here, we need you to do this, might be fine in what we might call the commoditized legal practice environment. We have a relatively streamlined conveyancing system. We have relatively streamlined probate administrations. We could say, yes, you can do those on a conveyor belt basis, essentially. And I don't mean to disparage the practice of conveyancing. It's really complicated in places, but it also operates in a fairly structured timetable. But if I've got a family lawyer on and we get 3 family violence applications this afternoon, and there's a genuine possibility of that happening from 3 to 5 in an afternoon if the All Blacks lose a game, then I need people who are both capable of addressing those matters urgently, but who are sufficiently resourced emotionally and intellectually to say, right, we're going to have to do 4 or 5 hours worth of work and drop anchor and get stuck into it. And if we're running on fumes, which is how the legal profession has prided itself, since the mid-80s, I often tell the story of going to one of my first job interviews, and I was a bit early, so I got stuck in the cafeteria, and there was a sign up, big poster. It said, "If you weren't here Sunday, don't bother coming Monday." And that was paraded with pride. Yes. Now, that's not taking any account of what your people need to be good at their job.
Absolutely. Totally agree. Resourcing and having that adaptive and continually flex work. Absolutely. So, Greg, personally, what do you do to build your resilience? Because, you have a stressful role and I'm sure there's lots of pressure on you. So personally, how do you resource yourself?
I'm really lucky in that my fantastic partner is a specialist trauma psychologist. So I go home to someone with a couple of doctorates who's got far more marks than I do. But prior to that, what I endeavoured to do was ensure that I took micro breaks in my day. My days are quite long because I have a litigation platform and a teaching platform. So today I was in a half-day hearing starting at 10 o'clock. So I met with the client at 8:30, which meant I hit the office at 5:30. I'm giving seminars this evening, so I'll finish at about 7:30, get home about 9 o'clock. And that's normal for 2 or 3 days a week. But if you try and do a 14-hour day straight, you'll find that the quality of your work deteriorates significantly. So what I do find is I've now finished my hearing. I'm heading into a client at 3 o'clock, so I can slot in a couple of hours. I can take the spaniel, our local therapy dog that my partner takes to work, go for a walk around the park for half an hour. It might seem in the macho model of practicing law and squeezing every cent out of your earnings capacity to be counterintuitive, but if you get out, blow the cobwebs out and just take a break. If you can't take a day off from time to time, at least take slots in your day just to de-stress and be you. Whether that's, we have a Netflix subscription. So halfway through a really hectic week, it's not unusual to come in and find an episode of Brooklyn Nine-Nine or something being played on the big screen. And the lawyers rolling around looking like they really shouldn't be allowed out without adult supervision. Because it's also, part of the reason why I do that is it engenders the notion that we're people too. And it says to my people, look, you can come and you can sit down, you can have a goof, you can have a laugh. That means that they're less remote in terms of engaging with me, but it also means that if they are bobbling and they're at a stage where they need additional support, I'm so regularly engaged with them as people outside of any discussion about work that I'll have the opportunity to see that.
Great philosophy. Great philosophy. Those micro breaks and allowing yourself downtime and time to connect and laugh, we know are so important. So throughout the whole COVID and you're operating through that, if you were to think of perhaps the biggest learning or an experience that you'll take forward with you and you could distill it down to one, what would that be?
I think it's the need to ensure that we deal with people, with our clients and with our practitioners and our colleagues, and indeed even with the judiciary, who are often seen as fairly remote and unapproachable. And it sounds counterintuitive, on roughly the same footing. That people are people.
Yeah.
To continue to proceed on the basis that, and that's not to say that there isn't due deference and due regard and due courtesy afforded across all of the respective roles, but we need to understand that this is a system. This is actually a system. It's not a series of individuals. My ability to get a response back from the court is predicated upon the registrar being well enough to be doing their job, being resourced enough to be doing their job. It's predicated upon the judge having access to both the information and the resources they need to review that material. So we saw in the COVID break points and stress points in that system where people disaggregated and they became individuals, or where because of technical failings we couldn't operate together in that whole of system sense. And I came out of it thinking a lot more favourably disposed to the notion of fully integrated legal practice. I'd often been inclined to the view that we were the lawyers, they were the court, although ironically I represent a significant number of court employees and a fair swathe of the judiciary from time to time, but that to an extent there was a remove between us and them.
Sure.
Now, what we're finding is that coming out of COVID, we're having triaging and development meetings with the judiciary. That the judges are coming in and they're just sitting down in the boardroom, in the mediation rooms with us and saying, hey guys, how are we going to make this efficient? And it's really that understanding that, without sounding too much of a hippie, that we are a community as a profession, which distilled for me, rather than any of the more technical observations about perhaps the deficits in how we work.
Great place to finish. Now, I really enjoy that word community, and I think it's one that hopefully we can start to continue to think about what that means. It's great to have you as part of our community, the College of Law, and out there practicing what you do. Been a real pleasure. Really appreciate your time. You now deserve a break. Go take the spaniel for a walk.
I will. Thank you. It's been a pleasure.
You're much, much, much welcome, and great to talk. And that's us signing off.